Today, we're very pleased to welcome Professor Carolyn Sutherland and Dr. Amanda Selvarajah. That's wrong. Selvarajah. And Carolyn and Amanda come from the Monash Business School, and we've been doing quite a few things with the business school recently. Just a few weeks ago, we co-hosted a conference in Malaysia, and that was the Asian Corporate Law Forum. And today they're going to be talking about resolving labour disputes in the Philippines, harnessing formal and informal mechanisms. And as I looked through the description of their seminar, it really struck me, just the parallels between what we were doing at the Asian Corporate Law Forum. This idea that often we take our paradigms from Western models and that they're an uncomfortable fit in the East. And also this idea of the difference between law on the books and then law in action. And so this is going to explore, how labour disputes are resolved on the ground, in action. And we're just so pleased to have you here because we want to do more with the business school. So this is really great to have you visit. I'm going to pass over now. Who's starting first? Carolyn, go.
Thanks, Jennifer. We're so happy to be here and really appreciate the invitation to be part of this CLARS Seminar series. I'd like to begin by acknowledging the people of the Kulin Nation. I pay my respects to their elders past and present and acknowledge that sovereignty was never ceded. Should I be facing all of you or should I be facing Zoom participants?
Whatever is comfortable for you. The Zoom participants can see you.
Yes.
Obviously, they can see the back of your head right now. But what is mainly on the screen is the slides anyway.
Mix. Okay.
Yeah. So whatever you're comfortable with.
Thank you. Our presentation today forms part of a larger ARC-funded project where we have been exploring how labour dispute resolution works in practice in 3 Southeast Asian countries, Indonesia, Vietnam and the Philippines. And you can see on the slide our colleagues on the project from Monash Business School and Melbourne and Deakin universities. Today, Amanda and I are presenting an empirical study that we've undertaken on labour disputes in the Philippines. And I'll hand over to Amanda to explain the context and design of our study.
Thank you, Carolyn. As Carolyn has mentioned, we're trying to do an empirical exploration of labour dispute resolution in the Philippines. We chose to focus on disputes relating to labour hire practices, and I'll expand on what we mean by that in a little bit, and taking a lens of regulatory pluralism, so looking at both formal and informal actors and processes, drawing on interviews and a couple case studies to explore when and why particular actors and activities were regarded as legitimate or effective. And I'll expand on each of these components in a little bit. So first, why disputes relating to labour hire practices and what do we mean by that? So as you can see on the slide there, it goes by quite a number of different terms in the Philippines, but it essentially refers to a triangular work relationship whereby a labour hire agency provides workers to a host organisation. And because of the contractual relationship between the labour hire agency and the host organisation, those workers that get farmed out get referred to as contractual workers or contract workers. Importantly, they are not independent contractors. They are typically employees of the labour hire agency, but usually at the heart of this dispute is that they want to be employees of their host organizations instead. So workers that are directly hired by the host organization are referred to as regular workers, and what the contract workers are typically seeking is regularization, which is to be hired directly by the host employer instead of through this indirect relationship. And there are a number of reasons as to why they might want to do this. So first, contractual workers are usually hired on very short successive contracts. So typically 5 months in order to dodge the legal protections against dismissal that would kick in at the 6-month mark. So this is why these relationships are also called end of contract or ENDO for short in the Philippines. Because they have no employment relationship with their host organization, they usually have no bargaining power to influence their working conditions, which translates into them working under poorer conditions, lower pay, and lower status. They're usually used to perform lower paid and lower skilled work, and usually are working under the direction of the regular employees, because supervisory positions and more senior positions are typically held by regular workers. So this again is contributing to wanting to be regular workers as opposed to contract workers. The very common form of work relationship in the Philippines, it counts for about 60% of their workforce, 25 million workers, and it is a very contentious issue. It was the leading cause for strikes between 2015 and 2020.
Can I just ask a question there?
Yeah.
So you think that if they, were regular workers rather than contract workers, they would have more bargaining power? I mean, do regular workers have a lot of bargaining power?
At the very least have the legal right to unionize.
Right.
Within their host organizations, whereas these workers are told to bargain with their labour hire agency because they have no direct relationship with them.
Yeah, because I was thinking as individuals, the regular workers would have very little bargaining power, but yeah, through unions. Yeah.
And this is sort of a deliberate mechanism as well to reduce the number of workers that can actually unionize against the employer itself, right? Because now the majority of their workforce are contract workers who they say have no direct employment relationship with them. And I should also notice the contract workers, even though they are typically hired on these short successive contracts, they can end up working for the same host organization for years and years. So we saw workers working with the same host employer for 10 years, 12 years. So they feel very connected to the host organization, but they have no direct employment relationship under the law. So it's also a very political issue. So it was one of the central campaign promises for Rodrigo Duterte that he would put an end to ENDO, labor-only contracting. During the first few years of his presidency, there was some increased enforcement activity. But when a bill that would amend the legislation came through the Senate, he ultimately vetoed the bill. So that means the rules have stayed the same now for quite a number of years. They are codified in the Labor Code and then have been given effect through administrative rules issued by the Department of Labor, which essentially says that these relationships will be illegal where the contractual workers are performing core activities for the host organization and the labor hire agency doesn't have enough tools or equipment to be seen to be running their own legitimate business, or where the labor hire agency is not exercising sufficient control over the workers, and it is, for example, instead the host organization that is controlling their activities. So if a worker has a dispute about their proper categorization as a contractual worker, there are several avenues through which they can raise a dispute within the formal legal system. If it's a collective dispute, it goes before the National Reconciliation Board. If it is an individual dispute, they can go before their quasi-judicial body, the National Labor Relations Commission. And then all of these branches are overseen by the Department of Labor, who is also responsible for enforcement activity. Within each of these entry points, there are multiple avenues for appeal, including through the court system. But as I was mentioning earlier, we were taking a broad understanding of regulation here. So we weren't just looking at the formal system, we were also looking at any norms that could be seen as governing human behavior and the actors involved in those processes as well. And this was because, like many other countries in Southeast Asia, the legitimacy and effectiveness of the state apparatus cannot necessarily be assumed. It's well documented that state actors in the Philippines are frequently engaging in regulatory conversations, trying to assert and reclaim their legitimacy over and over. So we wanted to explore how that legitimacy was shaped in practice. What we mean by legitimacy here is a perception that something is desirable. And we used 3 forms of legitimacy for our analysis: pragmatic legitimacy, so where it's understood to yield practical benefits; moral legitimacy, where something is seen as the morally correct thing to do; and then cognitive legitimacy, where something has established a certain level of taken for grantedness that you couldn't imagine doing anything else. So because we were conducting our field work during the COVID lockdown years, we were doing all of our interviews remotely, and it did limit our ability to recruit from particular field sites to speak with employers and workers themselves. But as you can see there, we did manage to speak to state labor officials, unionists, labor activists, and lawyers. And as I mentioned earlier, we used 2 case studies as well. The first is a dispute that took place over 8 years and largely involved the formal system. And then the second was quite an intensive year-long dispute that largely used informal processes and actors. And we also drew on traditional and social media reports, academic and grey literature, and court judgments as a form of doctrinal but also ethnographic data to inform our studies. So I'll now hand over to Carolyn to walk us through those.
Thank you. So the first case study is involving PLDT, which is the largest telecommunications firm in the Philippines, has a workforce of over 17,000 workers, and a very high proportion of the workers are contractual workers. They claim they were performing work that was integral to PLDT's business and that they should therefore be regularised. And as you asked, Jennifer, about the differences between them, essentially they want security and better conditions, and that's what happens. That it just is the way it is, that the regular workers get the better conditions. So the first step in the dispute was when the union sought regularisation of contractual workers as a key plank of its negotiations for a collective bargaining agreement at PLDT in 2016. The union claimed that thousands of PLDT's workers were unlawfully engaged as contractual workers, and this claim by the union triggered an investigation by the DOLE, which is the Department of Labour and Employment. In December 2016, the DOLE concluded that PLDT and 48 labour hire agencies were engaging in unlawful labour-only contracting. The DOLE ordered PLDT to regularise 9,120 workers. As is common in the Philippines, PLDT challenged those findings, and the DOLE conducted further investigations over 3 months, resulting in a reaffirmation of the regularisation order, but with the scope reduced to cover 8,719 workers. PLDT appealed 2 further times, and on these occasions it was the Secretary of Labour who reduced the scope of the DOLE's regularisation orders. So by the end of all these appeals, in April 2018, the number of workers to be regularised had been reduced from 9,120 workers down to 7,344 workers. The DOLE's next move was part of a broader campaign to combat labour-only contracting by naming and shaming firms engaged in the illegal practice, and this was part of the response of a new government having campaigned on this issue. When the DOLE publicised its list of the top offenders, PLDT was 3rd on the list. But instead of implementing the DOLE's regularisation order, PLDT terminated its service contracts with all of its labour hire agencies, resulting in those agencies dismissing 12,000 contractual workers. Those dismissals triggered a social media campaign using the hashtag #SavePLDTContractuals. This campaign shared the stories of the dismissed labour hire workers. The workers also protested outside the DOLE's offices, prompting the DOLE to schedule a mandatory conference to resolve the dispute. When PLDT failed to attend, the DOLE called a press conference in which it held up an order saying, this is how this has to happen, and unless you implement this order, we will take punitive action against you.
Can I ask a question?
Yes.
How were they going to fill the gap after they sacked all these people?
Well,
It wasn't like the waterfront dispute where they were secretly training people in the Middle East to bring them in.
Because we were relying on a lot of social media reports and media reporting, the details are a little bit scarce. But the impression I get is the employers in these situations just find a way to fill gaps. We'll see that there was pressure on the remaining employees.
Yeah.
But they find ways, yeah. So the next step was the workers protesting outside the DOLE's offices, and we'll see this is an uncommon practice. And that prompted the DOLE to schedule a mandatory conference. So we see here the interaction of the informal and the formal. When PLDT failed to attend the conference, I'm sorry, I've already mentioned that. And then around the same time, legislators filed a resolution in the House of Reps to urge PLDT to implement the DOLE's regularisation order. PLDT's next step was to challenge the order in the Court of Appeals. The court upheld the regularisation order, but restricted it to core workers, which it characterised as the installation and repair roles, whereas workers who were in janitorial, clerical, IT and sales roles were seen to be peripheral and not covered by the regularisation order. Despite that significant victory for the workers in those maintenance and repair roles, the media reported the decision as a loss for PLDT workers. The next event was for the union who represented the supervisors, so this goes to your question, Jennifer, at PLDT, to file their notice of strike. So they started protesting about the burden of work that had fallen to them because of the gap in the workforce as a result of these mass dismissals. The supervisors also protested outside the Dole's offices to seek implementation of the regularisation order. And then all of the parties to the dispute appealed the Court of Appeal's decision to the Supreme Court. And you'll see we've skipped forward in time. So we've gone from 2018. It took until February 2024 for the Supreme Court to hand down its decision, and it essentially upheld the Court of Appeal's decision. So to regularise the installation and repair workers, but not the other peripheral roles. In the course of its decision, the Supreme Court criticised the whimsical and arbitrary approach taken by the Dole in its original investigation of labour-only contracting at PLDT. And essentially it was saying that Dole had taken statements but hadn't gone on site and had a look at how things were actually working on the premises. In April 2024, the union representing regular workers filed a notice of strike after PLDT failed to respond to requests to start bargaining again for a new collective bargaining agreement. And in May 2024, workers protested again outside the Dole's offices, seeking enforcement still of the Supreme Court decision to regularise the installation and repair workers. A planned strike was only averted when PLDT finally agreed to commence bargaining. And this essentially took the union back to where it started in 2016 when it made regularisation a central plank of its bargaining platform. So that's the end of that case study. And the second case study involves Pepmico, which is a Filipino manufacturing company that produces popular brands of shampoo, toothpaste and detergents for the domestic market. In 2019, only 40 workers were regular at the Laguna factory, while 400 workers were contractual workers. These contractual workers claim they were working in unsafe conditions and that they were performing necessary and desirable jobs and should therefore be employed as regular workers. The dispute at the Pepmico factory began with the dismissal of 36 contractual workers by one of the labour hire agencies, and the contractual workers initially sought to form their own union, and they registered this union with the Dole. The workers then began protesting outside the Dole to prompt the release of the findings from a Dole investigation that had been conducted 6 months earlier into allegations of labour-only contracting at the factory. In response to the protest, the Dole issued its determination that Pepmico had not engaged in labour-only contracting on the basis that the labour hire agencies had control over the workers and the workers were performing non-core functions at the factory. A few months later, the Dole withdrew its registration of the union on the basis that there could only be one legitimate union, and that was the union representing regular workers. Around the same time, Pepmico arranged for the dismissal of around 200 contractual workers, including most of the workers who had sought to set up the new union. The deregistered union representing contractual workers still filed a notice of strike with the NCMB, the National Conciliation and Mediation Board, and then gathered to protest outside of the NCMB's premises. The protests were bolstered by a social media campaign which disseminated graphic images of the skin injuries sustained by contractual workers from the chemicals used at the factory. The NCMB attempted to conciliate, but PEPMCO refused to recognise the deregistered union or the strike and refused to attend further mediation conferences scheduled by the NCMB. The next step was June 2019, when worker protests outside the PEPMCO factory were violently dispersed by what workers described as goons dressed in battle gear, swinging batons and firing jets of water. But in media reports of the incident, PEPMCO claimed that it was the workers who had instigated the violence. Over the next few months, politicians provided their support to the cause, both by filing a resolution to investigate the dispute and by standing alongside the workers at the protests. At the same time, a consumer boycott of PEPMCO products and a social media campaign took hold, using the slogan, "Blood in your detergent." In August 2019, there was another violent dispersal of workers, resulting in the arrest of 25 workers, and with 18 of those workers being detained. But these workers were released the next day when the local courts found that law enforcement had not sought the necessary clearance from the Dole to intervene in a labour dispute. Alongside these events, between August and November 2019, there were concerts, solidarity marches and protests organised by the PEPMCO workers, often teaming up with workers at other factories who were in a similar situation to try to bring attention to the plight of contractual workers. Ultimately, there was no documented resolution to the PEPMCO dispute. The strikes ended in January 2020. Social media posts about the boycott continued until March 2020, but then the COVID public health emergency was declared, and subsequent posts on social media about PEPMCO workers were solely focused on a new campaign for quarantine leave. So that's the case studies. I can see some despondent faces. We also supplemented those case studies with interviews, as Amanda mentioned, mainly with Labor officials and participants in labour disputes, particularly participants on the side of workers. And what we learned from the case studies was reinforced by those interviews. Unions and labour activists repeatedly highlighted the weak pragmatic legitimacy of the formal labour dispute resolution system, or to put it another way, the formal system struggled to provide practical benefits to disputants. This was attributed in part to the eroded bargaining power and the formal role of unions as a result of contractualisation. When unions bring disputes to the Conciliation and Mediation Board, and they're raising concerns about the conditions of contractual workers, the NCMB can't compel the host employer to attend a mediation, since the contractual workers have no legal standing to strike. And the host employer can simply say that the workers are not their direct employees, so they have no responsibility for their working conditions or job security. So continually, we would read in the media the employers reciting this same phrase of, these workers are not our employees. Despite a lack of formal authority in this situation, the NCMB will attempt informal mediation and will offer what it called out-of-the-box solutions. For example, it would offer dismissed workers livelihood assistance or support, seeking training or alternative employment. Our interview participants overwhelmingly reported that disputants did not trust the formal labour dispute resolution institutions, and this affected both the pragmatic and the moral legitimacy of these institutions. The perceptions of corruption were widespread, particularly where an institution issued inconsistent decisions in response to identical facts, or where disputes progressed at a snail's pace, which was seen as benefiting the employer. In some cases, our interviewees told us the complaint would outlive the complainant. Interviewees also cited examples of high levels of government interference in support of the employer, including coordinated acts of violence to break up protests. Workers and their supporters tried to counter this through informal protests, social media campaigns, and appeals to Labor officials and politicians. And as we saw in the case studies, These informal strategies didn't necessarily lead to workers achieving what they were seeking, which was to be offered secure employment and better conditions. But our interviewees expressed optimism about the effects of informal actions in influencing the overall stance taken by the government in relation to the problem of labour-only contracting. So overall, our findings are consistent with the prevailing view that formal labour dispute resolution systems in the Philippines are not particularly effective, but we've also looked beyond the formal process to see how labour disputes are resolved in practice through the activities of multiple actors and processes, both formal and informal. One of the key findings of the study is that disputants continue to be highly engaged with formal institutions despite their apparent ineffectiveness. In the case of the Dole, the pragmatic legitimacy of Dole officials was undermined when they backpedaled on their own decisions and failed to enforce their own orders. And their moral legitimacy was called into question when they failed to assert their exclusive jurisdiction over labour disputes. Despite this, disputants continued to engage with the Dole. They lodged complaints, they participated in mediations, and they protested continually outside Dole offices. This suggested to us that the Dole retained strong cognitive legitimacy, so it was taken for granted as the recognised venue of labour dispute resolution. Our study confirms the importance of informal processes and actors to bolster the legitimacy and effectiveness of formal processes in jurisdictions such as the Philippines. Workers and unions frequently supplemented formal legal claims with informal action, and these strategies helped workers maintain pressure on employers and on formal institutions when formal processes stalled. When unions suffered legal setbacks, such as adverse rulings or deregistration, they sought to build moral legitimacy by emphasising workers' vulnerability and unfair treatment rather than relying on legal arguments. Informal processes such as consumer boycotts and interventions from politicians contribute to this legitimacy. A final aspect that became apparent to us throughout the study was that unions and labour activists maintained a broad focus beyond the outcome of the individual dispute. Each action, whether formal or informal, was taken as part of a broader collective campaign to drive political change, even where formal legal remedies were weak. Thank you.
Well, we're going to wrap up there. And if I can just thank Carolyn and Amanda very much, because that was fascinating. I loved the case studies as well. It really kind of brings it home to you. And I also loved the way the big themes, are very broad in commercial law. Meredith's giving you a clap on the screen and a heart. Oh, well done, Meredith. Okay, so thanks everyone, and we'll see you soon.